7th day of June 2023. And we are looking at companies in administration. We are continuing from where we stopped yesterday. And we're trying to look at the administrator at work. How does he go about his work? I told you that he has a very short time. He's being brought in to solve a problem quickly. He doesn't have all day to manage the company, and so the law imposes a time frame for him. He's required to perform his functions as quickly and efficiently as is reasonably practicable. As quickly and efficiently as is reasonably practicable. Section 445, you see that in section 445. So as a result of that, within 60 days after his appointment, first thing he's meant to do is to prepare a detailed schedule of the company's assets. I told you that you have to gather the assets and then submit it to the person appointing him. If it's a court, if it's a floating charge holder, if it's a company, you should submit that document. You want to know all that this company has, all of the assets, and all that. Good. After that, he is going to require a statement of affairs. He is going to require a statement of affairs from the company's either employees or officers or promoters. I want to know what has been happening in this company before I came on board. So first of all, I need a schedule of assets. These are the assets. Then I need to have a statement of affairs. Are you with me? Yes, so that he can be abreast with what is going on. Because remember that this man is just being brought on board to administer this company. And so that statement of affairs must be delivered to him. And of course, if you refuse to deliver it to him, you will be found in contempt of court, because at this point in time, he is deemed to be an officer of the court. And every reasonable requisition he makes should be responded to. The statement of affairs must be verified on oath, so it must be a true statement. If you tell lies in that statement again, you can be convicted for what? For what? What offense? Perjury. Matter, if a person lies on oath, they say he has committed an offense. That offense matter is called perjury. So the statement must contain particulars of the company's property, its assets and liabilities, the name and address of the creditors, and the security held by each of them, the date on which each security was granted, and such other information as may be required. And this statement must be given within 14 days. You cannot say, will they come, because at this point in time, like I said, he has to bring the full powers of the court to bear in administering this company and to forestall or prevent people trying to be funny. The law is giving us a time frame. Are you with me? You can't say, oh, will they look for that document 2 months. That means you want to frustrate the man. So 14 days within when he makes this requisition, you should be ready to give him this document. So officers, employees, promoters, any of them can be, what is it?
No battery, please.
No, don't worry, just continue. That is enough. I have up to 20. So after he has got all of these documents, he has the schedule of assets ready and then the statement of affairs. What we now expect from him to hear from him is, okay, what do you plan to do? How do you plan to solve this our problem? So he's meant to bring a proposal, because he's being brought here to solve a problem. So we want to see from you, section 486, a proposal for achieving the purpose of the administration. What do you plan to do? That is the next thing we now expect from him. And so in that proposal, if he feels that corporate rescue will no longer be achievable, but achieving a wider, an objective for the whole creditors as a whole rather than for the elite creditors, he should also explain why he thinks the first two purposes of administration cannot be achieved. If he now feels that the only thing we can do is to go straight to the last and very narrow option of addressing here the concerns of the elite creditors, then he should also in that proposal explain, this is what I think this company has gone too far, the assets are far below what to be able to satisfy all of the creditors. This company cannot be rescued as a going concern. Are you with me so far? Yes, so he will now do that. Among other things in his proposal, he may propose that the company should go into a CVA. So the company is in administration. While it is in administration, the administrator may now propose, let's go into a CVA. And when we're talking about a CVA now, we're talking about a compromise. Please remember that when this company is in administration, the administrator doesn't have the right to vary any of the rights of the creditors. All rights remain intact. The highest that the law says is that we can suspend your rights. So the company's administration doesn't mean if Palemoti is owed 1 million, administration does not bring that money to 900,000 for any reason. Because it is his property right and it must be paid in full. Are you with me? The rules of priority also are not jettisoned. The rules of priority are not jettisoned. They are not. I woke up, frankly, I woke up since 5 o'clock or 4. See the time you come class. Sit down. Don't come late again to my class. Can we continue, please? Yes, so I want to emphasize again, administration does not for any reason subsume or doesn't diminish the rights of creditors. The rules of priority are also not to be disposed with. They must be maintained. The only thing we are saying is that give this man space, let him work small. That is all we are saying. But now, if he now enters into the premises of the company, having had a comprehensive view of all the state of affairs, the documents and all that, he can now propose a CVA. When we come to a CVA, we are now talking about an arrangement. Is that not so? Yes. That may, among other things, result in compromises. And when we are talking about a compromise, you are not talking about you being ready to jettison some of your rights. Am I clear? Yes. Yes, so that this problem can be addressed, this problem can be solved. I am ready to let go of this entitlement, and you are also ready to let go of this entitlement. There will be a win-win situation or a lose-lose, either way we want to look at it. When we go into a voluntary arrangement, everybody will lose something, but everybody will also win something. So that's one of the proposals he may make. In the same or in a similar vein, he may propose for the company to enter into a scheme of arrangement, to solve this problem. For the voluntary arrangement, CVA, here the company is dealing with creditors. For the scheme of arrangement, the company may deal with creditors, or it may even now deal with a third-party company. We have already looked at that now. Yes, a scheme of arrangement may lead to a merger. So we are owing Dobeni Johnson. We don't have the money to pay him, but now let's go into a merger with ABC Nigeria Limited. Let them bring funds so that we can address some of our indebtedness to him. So these are some of the things he may propose. He must send this proposal within 30 days to the Corporate Affairs Commission, to every creditor of the company, and to every member of the company. Are you with me so far? Good. Sections 486 and 510, just again to emphasize, sections 486 and 510, that the proposal, among other things, must not affect the right of a secured creditor of the company to enforce his security. It must not affect the right of a secured creditor of the company to enforce his security. It should also not result in a preferential debt being paid otherwise than in priority to a non-preferential debt. I will explain. It should also not result in a preferential debt of the company being paid otherwise down in priority to a non-preferential debt. What is a preferential debt, Ogunka? Or who is a preferential creditor? You can sit down, sir. Can somebody help him? Cletus.
A preferential creditor could be, or is a person.
Yes, please.
That has preference in terms of payment.
Excellent. But to put it better, can somebody help him? That man close to Chief. Your name, sir? Yes, the man close to Chief Ombo. Your name, sir?
Gabriel.
Gabriel. Oh, yeah, Prekombo is true. Can you help us? Or you help us next time? Ogunka, no.
So let me put it better.
Yes, let's hear Cletus. Don't worry, Gabriel.
For instance, a company is owing 3 to 4 persons. And in the scheme of arrangement, they have an agreement.
Yes.
That in the event of 1 or 2 occurrence, that this man is going to be settled first. So if the company is going into suffering any stuff,
yes,
what happens is that this man that they have arrangement with will be the one to get payment.
Okay.
First.
Okay.
So he's preferred first.
Excellent. Excellent. In a layman's term, yes. But for us in company law, I explained to us that we have, in terms of seniority of creditors, we'll still talk about it when we come to liquidation of companies. But in terms of seniority of creditors, I told us that we start with a fixed charge holder. After him, we step down a bit to preferential creditors. Who are preferential creditors? I told us, first of all, we look at the taxman. Are you with me? The Federal Inland Revenue Service or any other tax obligation that the company was owing. Those obligations are preferential debts. You must pay that person first. But not just that tax, not just the taxman. There are other obligations the company may have to its junior employees. We'll still talk about it. For those of you who have bought my book, you can jump to the chapter on dissolution and see where we look at priorities in insolvency. That will give you a bird's eye view as well. So please come in. You step down a bit to the next group of creditors. Are you with me? Yes. Please sit down. This is the first day I'm saying this, Oga, in my whole life. Since my mother gave birth to me. See me after class. That man, see me. Can we continue? Good. So, please, let's not take all the time with preferential debt. So, the taxman, obligations to employees, what you call contributions the company ought to have been making. So, Palimote is our staff. We ought to have been making monthly contributions for him to the pension refund, pension fund and all that. We've not been making it. That money is a preferential. Are you with me? So if we are going into liquidation, we must pay all those ones first. So what Kama is saying here is that the proposal this man is making should not, among others, he said, okay, we should have paid tax first. But now I want to solve this problem. I'm now proposing that let's pay tax last. Kama says no. Your proposal should not be tantamount to saying that the preferential creditor should be paid last. It should not affect his priority in essence. I hope you are with me. Yes. Number one, don't affect the right of his secure creditor to enforce his security. Number two, don't jumble the order of priority. Don't say preferential creditor should be paid subsequent to. It should be paid as at when it should be. Number three, it should not result in one preferred creditor being paid a smaller proportion of his debt over another. That is number three. So he's a preferred creditor, and Martha is a preferred creditor. She's entitled to 40,000. He's entitled to 40,000. I'm proposing that Martha should now be paid 30 and let him be paid 35. You can't do that. That's why I told you that administration is not a time where you waive the rights of creditors. You can do that in voluntary arrangement because the man is agreeing. You can do that in schemes of arrangement again because people are agreeing, but you can't do that during administration. Number 3, I think that is basically. See also section 509. We'll talk about it. Section 509. Similar provisions are contained in section 509 with respect to assets acquired by the company under a purchase agreement. Somebody should read 509 for us quickly. Let's just say 1 or 2 things about it and then move on. Thank you, Lord. Quickly. I don't have camera here. Yes. How many subsections does he have?
It has 5 subsections.
Quickly, just go through.
The court may by order enable the administrator of a company to dispose of goods which are in the possession of the company under a hire purchase agreement.
Yes.
As if all the rights of the owner under the agreement were vested in the company.
You can sit down. Thank you. So please look up what Kama is doing here. Please look up. This is an asset that belongs to me. Title is, I have title. I've given it to Dobeni Johnson Nigeria Limited on a hire purchase arrangement. Title does not pass until he completes payment. Is that not so? Yes. But what is happening here is that Dobeni has paid, let's assume the money for the asset is 100 naira. Dobeni has paid 95 naira. 5 naira is left and he's struggling. The asset is in his possession. Under the hire purchase law, I have a right to go after that asset, either to recover it completely or order that it should be moved to the court. Are you with me? Are you with me? The moment the company goes into administration and the administrator enters into Dobeni Nigeria Limited, Section 509 is saying that the court may now order the administrator to sell that my property. But in selling it, so he sells the asset for 150 and 150 naira. In selling it, I will still have priority to share in that money. Because I was originally the person that had access. It was my property. Was it not so? Yes, that's what we're trying to say. I hope that is clear enough. Yes. It's not clear. Get the video or the audio later and listen. You guys are smart. In fact, you are smarter than me. Just I may be wiser than you. I used to tell my 13-year-old son, you are smarter than me, but I'm wiser than you. Wisdom takes time, but smartness, most of you are smarter than me. Balaru is smarter than me. Can we continue? Good, so you are all smart. Section 488. What does he do? The next thing is to do is to call for an ICM. Call for an ICM, initial creditors meeting. Call for an ICM. It must be held within 42 days after the company enters into administration. Call for an ICM and present these proposals. Call for an ICM and present these proposals. But he mustn't call this meeting if it's of the opinion that the company is solvent. If it's of the view that this company has enough assets. I've gone through the document. This company really doesn't have much problems. I don't even know why it went into administration. It doesn't have problems. So if it's of the opinion that the company is solvent, don't worry. Or if it's of the opinion that it has insufficient property to enable a distribution to be made to unsecured creditors. If he feels that the assets are not sufficient, by the time we sell these assets, unsecured creditors, nothing will reach them, then there's no need for him to call for an ICM. Thirdly, he mustn't call for an ICM if he's of the opinion that neither corporate rescue nor achieving a better result for all the creditors, that is objective 1, objective 2, are not going to be possible. What is objective 1 of administration? Go to number 1. Go to, yes, I want to marry him and bear his name. Yes. That is go to. I didn't call you. Go to. Corporate what? Good. Number 2. Chinonso. Chichi, number 2. No. That's my daughter. Help us. Yes. The second object of administration. No, ma. No, ma. Yes, help us.
Achieving better results for company's creditors.
As a whole. Yeah, so if it's of, so tell me, mustn't call an ICM if it's of the view that these two objects cannot be achieved. Are you with me? Good. So other than that, within 42 days after the company enters into administration, it should call for an ICM. An ICM may also be requisition. You know, we talk about requisition meetings when we looked at meetings. You remember? Yes. An EGM can be requisitioned. Yes. So something like that is brought to bear here under section 489. 489. All the people doing trusts, let me have your name so that I will know how to arrange with you. I have not heard from you people. Okay, section 489. It may be requisitioned by creditors again, and that are owed at least 10% of the company's total debts. Total debt. The company is going 1 billion. Then we look at 10% of that. 10% of the creditors may also requisition an ICM, and of course, if the administrator doesn't respond, then they can summon it. Are you with me? They can take the initiative and summon it and hold the meeting and all that. Now, what can the ICM do? It may approve the proposal without modifications or with modifications if the administrator consents. So, number one, you have brought a proposal, we look at it, we think it's okay, we approve it. So the administrator cannot work without getting the approval of the creditors. Here, members are put far in the back. We don't call a meeting of members as we do when we're entering into a scheme of arrangement or a CVA. Here, we only need creditors to give their blessing. Are you with me? Good people. Thank you, Lord. So, first thing the meeting may do, approve the proposal. Second thing it may do, modify it. But you can only modify it if he approves. If he does not approve, you don't have the right to modify. After that, you now go back to CAC and report the outcome to the courts. Report the outcome to CAC and to the courts. And note again that a further creditors meeting may be summoned by the administrator if requisitioned or if it's so directed by the court. So we have an ICM, initial creditors meeting, once, but we could still have subsequent creditors meetings. The administrator may also do that, or he may be requisitioned or to do that, or the court may direct him to do that. So please note section 493, please. Section 493. Please also note under section 491, note section 491 again, that he himself may revise the proposal. Pero, are you with us? He may revise the proposal, and if he does that, he is to summon another creditors meeting. He may go back while doing his work and discover that I should have done it like this or like that, and then he wants a second proposal to be approved, then he will have to summon another creditors meeting and send a meeting of the proposed revision along with the notice to the creditors of the meeting, creditors of the company, and all that. Again, so this is a second meeting that is being called to deliberate on his proposal to revise the proposal. I don't even understand. First, he brought a proposal, we approved. Subsequently, he felt, I need to revise this proposal. He can't do that on his own unilaterally. He's now calling for another creditors meeting, and so that meeting, if called upon, will consider the revision he wants to bring, and again, they could approve it without modification or with modification. Again, if he does what? Consents. Section 492, if the proposal is not approved, if the members do not approve the proposal, they have to get back to the courts. They have to get back to the court. And among other things, section 492, if the members say this proposal you are bringing is not realistic, we will not agree, is proposing that they should enter into a CVA, and they say we don't want to follow that route, or is proposing that we should have a scheme of arrangement that probably may result in a merger, and they still say we don't approve, then they have to go back and report to the court. And among other things, what will the court do? The court may hold that the appointment of the administrator has ceased to have effect. Has ceased to have effect. Of course, it may adjourn conditionally or unconditionally, but it may make an interim order for the winding up of the company. Remember, I told you when we looked at the effect of administration, I told you that among other things, it suspends. It could suspend a winding up order. It could even dismiss it. So but the moment the court is of the view that this proposal is not approved, that means this thing will not work because the creditors are not comfortable with it. And the court may say, oh yeah, let's now go to winding up. So administration is not by force. Cooper, are you with me? It's not by force. The creditors themselves must agree. And so when they look at that proposal, they say, this one way to talk, will not know it to talk. It will not work. And if they refuse, then among other things, the court will say the administration itself has ceased to have effect, and then it would, among other things, it may move for liquidation of the company. Now let's look at the duties of the administrator. His duties. Okay, you can look up. Basically, his duties, of course, he has to act in good faith. And he should, I didn't see that in camera though, but I want to believe it should be implied that the administrator should be a fiduciary, because good faith obligations are also imposed upon receivers and managers. So I want to believe that the good faith obligation would also be implied here. Definitely, it should also be skillful. It shouldn't be negligent, because among other things, these are not duties that are specifically imposed, but you will discover that one of the grounds upon which he can be removed is if he is negligent. Are you with me? Are you with me? So if he can be removed on the basis of negligence, we want to imply that he has a duty not to be negligent. I don't know if you understand, but I didn't see that specifically stated in camera. But apart from these general duties, he has specific duties that have to do with notifications, duties to the court, duties to CAC, and notifications and filings, if you want to. Filings with the court, but basically filings with CAC and all that. So please look at section. Yes, okay. So in the course of reading, you will just see notify CAC, notify the court, notify CAC, and all that. But now let's just focus. We'll soon be done. I just have 7 slides more. Thank you, Lord. Let's look at the powers of the administrator. We'll run through this one. We want to look at section 496 and combine it with schedule 11 to the Act. Section 496. If you are you with us? And schedule 11 to the Act. Section 496. Schedule 11 to the Act. Okay, so he has his powers. You can look up at me. Look up at me. You remember when we looked at the organic structure of the company first semester and the division of the company into organs? We emphasized that the company has 2 broad organs, the members in general meeting and then the board of directors. And we also pointed out that in some instances the MD could be an organ and all that. We also emphasized, that should be section 87 or 89, that the powers of management are inherently, conferred on the board of directors, except the articles especially and provide otherwise and all that. The moment an administrator is appointed, those powers of management are suspended. The powers of the directors to manage the company are suspended. And interestingly, they are now conferred upon one person. This person, like I said, is meant to be a specialist at corporate rescue. And if he's going to be a specialist at corporate rescue, he should be somebody who is very good in negotiations. He's somebody who should be very adept in finance as well. So we looked at section 705 or thereabout, the qualification. There could be a lawyer, it could be an accountant, as the case may be. Are you with me so far? And so it should be somebody who should be able to bring a quick solution to turn around the fortunes of this company. And so to enable him rescue this company or achieve the objectives of administration, section 496 links us to section schedule 11 and tells us of his powers. I will run through some of them. There are so many. I just run through some of them. May do anything necessary or expedient for the management of the affairs, business, and property of the company, and he may exercise additional powers as contained in Schedule 11 to the Act. So the main thing is that he may do anything necessary or expedient for the management of the affairs, business, and property of the company. Affairs, business, and what? Property. Anything necessary or expedient. But Schedule 11 now gives us what we call additional powers, or elaborates on his powers. Among other things, he may remove or appoint a director, or fill a vacancy in that regard. He may sell the company's property that is subjected to a floating charge or to a fixed charge if the court consents. So that your property was secured by a fixed charge doesn't mean that the administrator cannot touch it. People, are you with me? The administrator can still sell even a property that was secured with a fixed charge, or a fixed charge that was secured with a property. That property can still be sold by the administrator. But again, in this instance, he will need the consent of the court. He will not need your consent. He will need the consent of the court. And once he does that, you will still have priority if he's going to share the money. Are you with me? That comes as a result of that sale. Because I may have secured my funds, and this property again may be worth 10,000 naira, and I may have used it to secure a fixed charge over this man's money, which is just 100 naira, for God's sake. The company goes into administration, and this might say, don't sell it to have a fixed charge. No. We are in a problem here. We need to settle other creditors. And so with the consent of the court, I can sell this thing for 10,000 naira. After all, your money is just 100 naira. Then I will now share the money. But in sharing the money, he will have what? Good students, good lecturer. Good. So he may call meetings of members, meetings of creditors. He may take possession of the company's property. So please take your time and look at my book first. Then look at Schedule 11. Then look at my slide 24 and slide 25. Is that okay? Yes, sir. Okay, so let's just run quickly. Rights and privileges of secure creditors during administration. Sections 507 and 509. Sections 507 and 509. Rights and duties of secure creditors during administration. So please look it up. I've already said it. Rights and privileges of secure creditors during administration. Administration does not jettison with their priority rights. Secondly, even if you must sell assets, fixed charge assets, he must do so with the consent of the court. And I didn't add that one. He must convince the court that the disposal of this asset will likely promote the purpose of administration. That, my lord, this laptop is worth 10,000 naira, and this fixed charge holder, Dobeni Johnson, we are owing him only 2,000 naira. My lord, the aim of this administration is to satisfy creditors, all the creditors as a whole, or to rescue this company as a going concern. If we sell this asset, we'll be able to have 8,000 naira on top that we'll be able to use to satisfy GoTo and Focados. Are you with me so far? Yes, sir. Good. So that is the second one I want you to have at the back of your mind. What section did I give you again? Good. Good people. So look it up, and all that. Okay, so we're almost done. Termination. When does it end? I told us after 1 year. Actually, the law uses the word 12 months. 12 months is different from 1 year. 12 months is not the same thing as 1 year. For the layman, yes. But when the law uses 1 year and when they use 12 months, it's not the same thing. Are you with me? Yes, so I think what we use here is 12 months. Section 513. Somebody should look it up quickly. 513. I think it's 12 months there, not 1 year. Quickly.
Section 513.
Yes, please.
Subject to subsection 2, the appointment of an administration shall cease to have effect at the end of the period of 1 year.
Okay, it's 1 year, then it's okay. Thank you. Not 12 months now. 1 year. Okay, so like I told you, the court may extend it for a further what? 6 months. So 513, 514, and all that. So after 1 year, it terminates, except there is an extension for a further 6 months. It may also terminate upon its own application, section 517. He may also apply and say, my Lord, terminate this thing. If he thinks, one, that the purpose of administration cannot be achieved. Two, the company should not have entered into administration in the first place. One, my Lord, the purpose cannot be achieved. I've gone through the whole proposals, I've gone through the facts, I've gone through the documents, I've seen the accounts, I've seen the amount of creditors they have. This thing will not work. So it can terminate. It applies to the court. Number two, like I said, if he also feels that this company should not have even entered into administration in the first place, the administration will terminate. The process will terminate. Thirdly, if at the creditors meeting, the creditors now say, Oga, apply to the court to terminate this thing. So if he's so required to apply for termination by the creditors meeting, then he will apply to the court and say, my Lord, let this thing end. Number four, if the purpose for the administration itself has been sufficiently achieved. We are looking at sections 517. See also 518, please. 517, 518, please. Okay. Note also that under section 520, the administration itself may also cease, cease, of course, cease and terminate should be the same thing. Cease, where a winding up order is made on the grounds of public policy. Section 521, public policy. So this company is already in administration and we want to wind it up. Wind it up for public purpose on the ground of public policy. I gave us some examples yesterday. You remember? Yes. So if we make a winding up order, then forget about administration. Don't rescue the company. Just go straight to liquidation. Again, if the winding up order is made on the ground of violation of banking or insurance laws, it will also cease. So if the court appoints a provisional liquidator, can we continue? We are looking at 520, 521, 520 to 522. It will also cease after he has paid 521. After paying or setting aside funds for secure creditors and paying all unsecured creditors. He will notify the courts and the creditors, and the administration will see. So basically, when he has finished his work, are you with me? He paid. These are secure creditors. He pays them. These are unsecured creditors. He pays them. He notifies the courts. He notifies the creditors. Then the thing is over. Even if he doesn't pay the secure creditors, but he sets aside funds for them. I don't keep on our money for bank. They have rest of mind. Then the company is through with administration. Either they go to winding up, or they continue as a going what? Concern. Under 522, it will also cease if it's of the view that the company does not even have property which may be distributed to its creditors. There is no property to distribute anywhere, my Lord. That thing that they say that they have, when I went in and looked at the books, it's not even their own. Are you with me? Good. So, the more you look, the less you see. It's when you go inside that you will know that it is not as it was from outside. That's why you shouldn't be in a hurry to conclude. Clearly, most of my young people, after I talk of marriage, I don't want to hear of divorce. In Jesus' name. Amen. Don't marry in a hurry. Take your time. I courted my wife for 5 years. 2004 till 2009. She was asking me questions. Questions. What do you think about divorce? What do you think about alcohol? What do you think? Question. Ask the man that you want to marry. Question. Ask him what? I will answer. Is alcohol a sin? I say it's not a sin. What? Will you drink alcohol? I don't drink alcohol. We will argue this one. Argue. What do you think about polygamy? I say it's not a sin. Will you marry a second wife? No. Don't mind me. I have some radical views. We probed till we finally married. 14 years of peace. It will be like that for you. So they say you want to marry a woman, don't rush, because, as a pastor, I'm a pastor. I don't know how many of you know I'm a pastor. You don't know? As a pastor, you get to see things. And nothing breaks my heart more than a marriage that is failing. Nothing breaks my heart more than that. Two good people, marriage is breaking. What about the children? It's not your portion, no. It's not a good thing. It's not a good thing. Okay, so if it's of the view that the company does not have property which may be distributed, then administration shall also in section 522. Please bear with me. I just have 2 slides more. And 2 slides more. Okay, resignation and vacation. He may also resign, of course. He may also resign. Section 525 to 528. Resignation and vacation of office. Okay. Yes, so he may resign, of course, by sending a written notice. Anybody can resign now. Is that not so? Yes, the law is that send a written notice to the court and basically to the creditors who appointed him. Then you can resign. I'm not doing it again. So we are looking at resignation. Here, administration has not ended. Instead, the administrator is leaving office. So another person probably can replace him. He may also be removed. So now we're looking at removal. He may also be removed by the court, irrespective of who appointed him. That's the next one, section 525 to 528. Thirdly, he will vacate office if he ceases to be qualified to act as an insolvency practitioner. So you have been debarred. The legal practitioner disciplinary committee says, Oga, you are not a fit and proper person to be a lawyer, so we are debarring you or suspending you from acting as a legal practitioner for the next 10 years. Then you cannot act as an IP, because that is the plan. Is that also upon which you were appointed? So please just note that removal. Let's now focus on removal. A court-appointed administrator, I've already said that, may be replaced by it on an application by the creditors committee. So the creditors committee, if the court appoints a person as an administrator, the creditors committee, so the creditors, the company may have 1 million creditors, 10,000 creditors, and they cannot always be coming together to solve things. So usually what will happen is that they will select a committee. Are you with me? Yes, sir. A committee of the creditors, 4 or 5 people and all that. This committee may also approach the court and say, my lord, this man that you made administrator, we don't know what it is, it's causing confusion. Remove him. Are you with me? Yes. Good. And where there's no creditors committee, or where there's no creditors committee, or where the administrator is negligent, or where he is negligent, where there's no creditors committee, or even if there is one, and they are also negligent, maybe they have taken bribe from him, then the company may approach the court and say, my lord, remove this man. The directors may approach the court. One or more creditors may do so, or joint administrators. I didn't say that you could appoint one person as administrator, you could appoint 5, you could appoint 10. If they are joint administrators, then if there are 3 of them, 2 of them can approach the court and say, my lord, remove this man. Are you with me? Yes. Good. The court, okay, so please let's continue. Section 519, the court may also remove him on an application of improper motive. Please listen, the court may also remove him on an allegation of improper motive, either on the part of the person who moved the court to make the administration order, that is the person who made the administration application, or where the administrator is appointed out of court on the part of the appointer. In either way, in either instance, the court may also remove him. Lastly, replacements. He may be replaced if his directors appointed him, they can replace him. So let me just read what I have here. If appointed by the company or his directors, he may be replaced by them, provided the consent of each floating charge holder is sought and obtained. The court may also replace an administrator upon an application made either by the creditors committee, the company, the directors, one or more of the creditors, or by a joint administrator. So the court may replace him and administration continues. The holder of a floating charge in respect of the company's property may also apply to the court to replace him with another administrator. And lastly, when an administrator is appointed by the directors or the company whose assets are not secured by a floating charge, the creditors may replace the administrator. So please look up section 536. Upon cessation, what happens? Upon cessation, what happens? Please look up section 536. Himself is discharged from liability in respect of any of his actions as administrator, and his remuneration and property. He will be remunerated from the property of the company that is in his control. 537. So please, I want you to take our time. I think we are basically done. I'll take a few questions, then we'll go into our presentation. It's quite, like I said, it's a new area of law, but it's important that you have a grasp of it. Martha, remind me to send us a link. There's a lecture that, the Nigerian Bar Association, we have what they call this continuing legal education something. So a training is coming up. I think it should even be today on corporate insolvency. So I will send that link to the platform so that you can connect. Are you with me? And then hear from them what they have to say and compare it with what you. Of course, what they will be saying will be in a summary form. They will not be as detailed as this, but I feel you should also benefit from that perspective as well. Are there questions? Are there questions? Yes, let me start with the Bitimi Jacob.
My question is there a difference between corporate rescue and business rescue?
Good good question from an intelligent girl. Thank you. Yes, technically speaking, yes. You can have a company, and that company can have 2, 3, 4, 5 businesses. Are you with me? Yes. We have business A, we sell soap. Business B, we sell crayfish. Business C, we sell books. Business A and B may be doing very well, and business C may be having problems. Is that not so? Yes. And so we can deploy some strategies or mechanisms to rescue business C. So it's not necessarily the same thing as corporate rescue. In another sense, business rescue could be wider than corporate rescue, because it may also entail rescuing a partnership firm that is about to collapse, rescuing an LLP that is struggling, or any other business firm, even a sole proprietorship business that is rescuing. So business rescue, in that sense, is broader than corporate rescue. In this second sense, corporate rescue is broader than business rescue if we are dealing just with one company that has several businesses. Then we may rescue business A and business B and say, no, that one, let it just, let that one die. These two, okay, let's continue with it. Are you clear? Somebody was asking another question. Yes, my dear. Yes.
The rights of the landlord,
Yes.
as well as that of the hirer,
Yes.
placed on abeyance. My question is, let's say I've hired my Bugatti to a company,
Yes.
and then they have to pay me instrumentally, let's say twice a year. Now the company is going to administration, and the period is 1 year. It means that before that 1 year, my installment will have been due over twice or so.
Yeah.
So the question is, can the company, when the company recovers,
Yes.
will it be able to pay me my backlog?
Will it have to pay me my backlog?
Yes.
It has to. That, like I told you, administration, that is an intelligent question from an intelligent man. The administration, to emphasize, doesn't suspend your rights. I am a landlord. I've let my house to you for 2 years. You were to renew my rent at the end of 2 years. You failed to do that. And so I gave you a notice to quit. The moment I gave you a notice to quit, I terminated the arrangement. Are you with me? You are no longer my tenant. I'm no longer your landlord. You are now an occupier. I am the owner. So we don't refer to ourselves again as landlord and what? That one don't end. Instead, we're not talking about owner and what? Occupier. As an occupier, you are mandated to pay me what they call mean profits. It's pronounced mean, but it's spelled MESNE. For holding over my property. So, if you now go into administration, and my right to recover is suspended during the period of administration, you will still have to pay me my money. Are you with me? You cannot say because I went into administration, I will not now pay you the money. You have to pay. Somebody met me recently. He wanted me to give him the kind of advice he wanted to hear. The one I gave him, he didn't like it. His landlady had given him quit notice. He said he's entitled to, according to me, he's entitled to 3 months. And during that 3 months period, he will not pay rent. I said, oh, guys, it's not like that now. Use your common sense. Is it fair? Is it fair? Is it just? Somebody's house. So that concept is brought. So if you are with my assets, my property, that you are buying on a hire purchase arrangement, you were to pay 10 million naira in 10 monthly installments. You paid for 8 or 5 or 6 or even 1 month. You defaulted and went into administration. I'm not after the car, I'm after my money. The law says that right to go after the car is suspended while administration is on course. But I will still be entitled to my money. All the installments. So even if they sell that Bugatti, eventually, then the 9 remaining monthly installments, I must be paid first. Are you with me? Doesn't affect priority. I hope that is clear. Because you came late, if not, you will have heard. Any other questions, please? Yes, my dear.
For the commencement of the administrator, if appointed by directors or the company, you say he can be removed by directors and the company.
He can.
Is this still subject to the confirmation by the courts?
Okay, just a second. I think you will need to notify the court. Just a second. Okay, I don't think you get back to the courts. What you need to do is to notify the floating charge holders and obtain their consent. But please, still check it up for your own confirmation. Is that okay? Yes. Good. Any other question? So you understand this topic very well. First thing you need to do is not to, like I told you, break your head too much with nitty-gritties. Number one is to have a firm understanding of the principles, the underlying principle, the structure, before you now start to fill in the gaps with details. So that even if you're not filling those gaps with those details, but you have the structure, the skeleton, the substance, then you are good to go. And that is what you need to pass here and to pass in law school. Have a bird's eye view. You know what this thing is about. It's about corporate rescue. Corporate rescue is not possible. Then how can you help all the creditors together? If that is not possible, then you step down thirdly to addressing the narrower interests of elite creditors. And those elite creditors are either secure creditors or what? Yes, preferential creditors. So please go back again, do your reading, and then listen to the audio, read the book, read the articles. Have I given you any articles on this? Mr. Palimote, remind me, I'll send you 5 articles, which you have to read, because I've given you a test from this topic. When should we set the test? 2 weeks from now? Go 2 weeks from now. So I'll send you 4 or 5 articles so that you have it. Because I want you to be masters of this topic. Okay, so I think we are ready for our presentation. My daughter, up these things. Thank you for your time.
Thank you, sir.